Hey everybody, John Skiba here from the Consumer Warrior YouTube channel. And in today's video, I'm going to talk about what's a case killer for most consumers that are defending a debt collection lawsuit. And that is the motion for summary judgment. In this video, I'm going to talk to you about what that is and how you can defend against it. If this is your first time here though, please check subscribe. That way you'll be notified each and every week when I put out a new video that'll help you deal with your serious debt problem. And if you're watching this video, know that this is video 4 of a 5-part series on how to defend debt collection lawsuits. You'll find the playlist on my YouTube channel. All right, let's talk about motions for summary judgment, what they are. Kind of big picture, there are really 3 ways a judgment can be entered against you in a debt collection lawsuit. One is to not file an answer to the underlying complaint. A default judgment will be entered then. 2 is if you go all the way through the case and go to trial, and a judge decides that there's enough evidence on behalf of the plaintiff and they enter judgment against you. And 3rd is a motion for summary judgment. Now, the way to think about a motion for summary judgment, this is where there's no hearing, there's no evidence, there's no cross-examination. This is when the plaintiff takes their documents, their evidence, and they draft a motion and they basically say, here, judge, take a look at all of this and tell us if we win this case. Essentially, they're saying, we don't need trial, just let's take this to, take a look at this and tell us we win. Now, you have to respond to this. If you don't respond to this, it's likely that a judgment is going to be entered against you. In most states, you're going to have about 30 days to respond to it. And the response to summary judgment can be very difficult. It's much different than filing an answer to the underlying complaint. And the attorneys for the junk debt buyers and the debt collectors, they know this. And so they know if they submit the motion for summary judgment, most non-lawyers will struggle in responding adequately. It's one of the reasons I put together an online tutorial with a template. I'll put a link down below the video here because it's complicated. To be able to respond to it adequately is complicated. But what I wanted to do in this video is kind of give you the big picture of what you need to do. And then if you want to dive deeper, you can check out the link with the online course. So the motion for summary judgment, like I said, is then, here's in essence what they're saying under the law. The creditor is saying, judge, there's no factual disputes. The parties agree on everything. Just apply the law to this and tell us if we win. Now, your job then to defeat summary judgment is that you need to show that there are factual disputes, that the parties don't agree on everything, and thus the case needs to go to trial, either before a jury or a judge, so that those factual disputes can be ironed out before the law is applied to it. Now, in most civil cases, summary judgment, it's not granted that often. And if you do it correctly, if you respond to it correctly in a debt collection scenario, it shouldn't be granted often either. Because particularly if you're dealing with a junk debt buyer like Portfolio Recovery, Unifund, Cavalry, Midland, all those guys, there are factual disputes because you didn't take any loans from those debt buyers. They didn't pay you any money. You didn't agree to pay them back. They are claiming that they purchased the debt and then they're coming into court saying that you need to pay us. You need to write a check to us even though we're not the ones who lent you the money. So there are factual disputes of you saying, look, from what they're providing you, I don't know if my particular account was included in that transaction. And that the problem is that their documents don't support that usually. They're very generic. They don't show which particular accounts, particularly your account, whether it was included in the various transactions between all the different debt buyers. That's a factual dispute that needs to be resolved at trial. Other common factual disputes are the amount of damages they're owed. So they not only have to prove that there was a contract, that you breached it, and that it was transferred to them, but they have to show how they calculated the damages. They've got to show how they came to the dollar amount. And in most courts, just offering a conclusory, you owe me $5,500, that's not going to do it. They have to go through and show how they came up with that particular number. Particularly if you think that the number is different and if you have any evidence to contravene that, you need to bring that up in the motion in your response to motion for summary judgment, and that will defeat that. This is also a good place to raise objections to their evidence. I often get asked in the YouTube channel in the comments, how do you raise some of these objections to, the document being hearsay or it's not a business record? This is the time you can do that as well, is saying, look, judge, not only are there factual disputes, but the evidence that they're relying on is not admissible. because it's hearsay. They haven't laid foundation for it. And I go over all that in other videos. And in tomorrow's video, I'm going to go into that in a really deep dive as far as how you make those objections and what those objections are. But that's how you respond to the summary judgment. Those are the type of issues you need to bring up. Again, it's really hard to do in a 5-minute video to explain exactly what that looks like. But the big picture that you've got to keep in mind as you are drafting a response is you need to show the court that there are factual disputes between the parties that need to be resolved at trial. This isn't something where everybody agrees exactly what the facts are and the judge just needs to apply the law. That's not this scenario. So if you do that, you're going to have a good chance of being successful in responding to your summary judgment. And what that means is the court denies the motion and sets the matter for trial, where you can come in and raise your defenses. So I hope that's helpful in understanding what the motion for summary judgment is, why it's so vital. You have to respond to it. If you don't respond to it, in many jurisdictions, the court interprets that as you are okay with it being granted. So you've got to respond to that motion for summary judgment. And if you do, and if you show that there are facts in dispute, you should be successful. Thanks for watching today.